Appreciate that. Let's see. All right. Do both sides have a representative available here today for pretrial matters, I should say?
Yes, Your Honor.
Yes.
Excellent. All right. Would the plaintiff or prosecution like to begin?
Yes, Your Honor. Good morning, Your Honor. My name is Jada Hayes, and I, along with my co-counsel, Taylor Corrine Benton,
Good morning, Your Honor.
and Sophia Cava,
Good morning, Your Honor.
represent the state of Midlands in this case. Your Honor, we have a few documents to tender to the bench: a copy of the indictment, the stipulations, discovery and response, relevant case law, orders on motions in limine, special instructions, copies of the Midlands Rules of Evidence, jury instructions, notice of intent to offer character evidence. May I tender the documents through the chat?
Absolutely. Has defense seen all these documents, and do they have any objections to them?
Yes, Your Honor. We've seen the documents and no objections.
Fantastic. You may go ahead and tender the documents in the chat. Excellent. Anything further from the state?
Yes, Your Honor. At this time, Your Honor, the prosecution has a few pretrial matters to attend to. We would like to invoke Rule 615 of constructive witness sequestration barring party representatives. Our party representative in this case is Detective Chesney.
Excellent. Does the defense have any party representative they would like to designate at this time?
Yes, Your Honor. We like to invoke Rule 615, the constructive sequestration of all witnesses bearing party representatives. The defense has the party Jordan Ryder present today.
Okay, so your party is going to be Jordan Ryder?
Yes.
Okay. Does the state have any objection to the invocation of 615?
No, Your Honor.
Okay. We'll go ahead and constructively do that, obviously, with the understanding that both aforementioned parties will be in for the duration of the trial. Okay. Anything else from the state?
Yes, Your Honor. May we assume that all witnesses have been pre-sworn under Rule 603?
Absolutely.
And may we assume that all objection arguments are made outside the presence of the jury?
Yep, absolutely.
And when an objection is sustained, should we move to strike or consider that evidence already stricken?
Go ahead and move to strike, whatever the offending portion is. I'm sure in some cases there will be instances where some of the answer will still remain on the record. So feel free to ask for a specific portion to be stricken if there's a sustained objection.
Thank you, Your Honor. And should we ask permission to share our screen with any exhibits or documents, or should we do so freely?
You can do so freely. Just go ahead and state it for the record, which one you're sharing. And then obviously it'll be the understanding that the jury won't be able to see these documents. It'll just be for the purposes of getting the documents identified. And then we'll go through any kind of admissibility issues before the jury sees it.
Okay. And may we address Your Honor as both judge and jury?
Yep, absolutely.
And with that, Your Honor, the state is ready to proceed with opening statements.
Wonderful. Defense, do you have anything else that you would like to go over quickly before we begin with opening statements?
Just introductions, Your Honor.
Absolutely.
My name is Jalen Higgins, and I am joined by my co-counsel, Sophia Tuscan.
Good morning, Your Honor.
And Charles Damasio.
Good morning, Your Honor.
And we represent the defendant in this case, Jordan Ryder.
Good morning, Your Honor.
And with that, we have ready to proceed with opening statements.
Fantastic. Well, let's go ahead and get right to it then. Would the state like to proceed with their opening statement?
Yes, Your Honor. May it please the court? Members of the jury, we are here to seek justice for a 12-year-old Parker Page, a victim of a parent's tough love that was just too rough. Now, the defense may argue Jordan Ryder was simply a mother doing her best, trying to make up for lost time, and Parker Page simply wandered off, perhaps slipped or fell. However, we will prove beyond reasonable doubt that the defendant is guilty of knowingly committing the murder of Parker Page. Jordan Ryder, the mother of Parker Page, had previously been incarcerated in a domestic violence charge. While in prison, the defendant lived in a fantasy consisting of adventures and explorations fueled by old memories of her daughter and the letters exchanged during her 6-year sentence. You will hear how this fantasy began to crumble and resulted in the loss of a child's life. The prosecution will call 2 witnesses. First, Detective Chesney, the lead investigator and officer for the Midlands Center Police Department. He works to investigate the major felony crimes of Midlands, examples being kidnapping and murder. Detective Chesney will provide a timeline of July 14th upon his arrival at the Calkin campgrounds, as well as his encounter with the defendant. Secondly, from Kelly, who traveled to Midlands hiking trails and was aware of the danger of Lecron Loop. She'll attest the clear annoyance and frustration Jordan held towards Parker and heard the final scream of Parker Page. On July 14th, the defendant had taken her daughter to Calkin camping grounds. It was a hot, sweltering day, and that only added to the building frustration inside of Jordan. Now, it didn't help that Parker did not play the assigned role in the defendant's fantasy. You see, Parker had brittle bones disease, a disease that weakened her bones and heightened the danger of minor accidents. A simple slip of the foot could result in extremely expensive hospital bills, only adding to the separation of reality from fiction and reinforcing in the defendant that the adventures they dreamed and sought after may have to come to a halt, thus contributing to the rising tensions between Jordan and Parker. With this in mind, the defendant chose the most dangerous path, the Lecron Loop. A sign at the beginning clearly stated the risk of falls and uneven ground, but of course, only out of love was this path chosen to prove how brave, strong, and independent she was. The defendant carried on. Parker, now limping in pain, reluctantly followed. With complaints of the discomfort filling the air, the defendant's frustration only grew, beginning to boil under the surface. You'll begin to understand why the defendant assumed their love was stronger than logic. No, she didn't need that hiking stick, and in a fit of anger, tore away that hiking stick. A mobility aid recommended by doctors to prevent fractures, a tool meant to preserve mobility. A tool meant to preserve her strength was torn away out of love. Out of love. You'll come to find in this fit of anger and pent-up frustration, the defendant pushed her 12-year-old child, ultimately to her death. And all that remained was a reality-stricken parent holding on to a hiking stick that once belonged to her daughter, who then now laid lifeless at the bottom of a 40-foot drop. Members of the jury, this is what happens when tough love gets too rough. And at the conclusion of this case, we will ask for a guilty verdict, and members of the jury will find the defendant guilty for the aggravated murder of Parker Page. Thank you.
Thank you very much, counsel. Does the defense have an opening statement they'd like to present at this time?
Yes, Your Honor, we do have an opening statement.
You may proceed when ready.
May it please the court. Parker, you know I'll always love you. Those were the last words Jordan Ryder uttered before her daughter's death. And this is only a glimpse of the love and support he always presented towards Parker Page. As she wrote letters from prison, Jordan, excited to come home, was always quoted saying, "Stay strong, stay brave." She promised more superhero adventures and assured that her daughter will be safe. Jordan Ryder wanted to get Parker out of an environment where she wasn't taken good care of. Living under Corbin, Jordan's half-sibling, Parker witnessed an individual that was constantly consuming drugs and cared for her own pleasure. Jordan Ryder believed that Parker deserved to live in an environment with more stability and more emotional support. But the moment where Parker Page fell off that cliff and died, the opportunity to give Parker what she always deserved went away. just like that, with tears running down her eyes, thinking about what she could have done for Parker. The pain that Jordan went through that night was unexplainable. No one can ever fathom what it's like to lose a child. But when one finds himself sitting in an interrogation room and is seen as the primary suspect of a child's death, that pain eventually builds into more and more trauma. That's what Jordan Ryder went through days after Parker Page's death. From the moment she was brought into the interrogation room to the interrogation of the other witnesses, it was clear that the police officers rushed the investigation. No DNA evidence, no eyewitness testimony. If there is no clear evidence to prove that Jordan Ryder is guilty beyond reasonable doubt, one thing stays true. Jordan Ryder was wrongfully accused of aggravated murder. It is the prosecution's burden today to prove to you that Jordan Ryder did in fact push Parker Page off a cliff and died. By the end of this trial, they must show that their story is the one and only logical explanation to Parker Page's death. And if there are any lingering questions or inconsistencies within the prosecution's case, it is imperative that Jordan Ryder be declared not guilty in the death of her daughter, Parker Page. Later today, you will hear from two witnesses, one of them including Jordan Ryder herself, who will tell you more about the events leading into Parker Page's death. First, you will hear from Cameron Lee, a camper at the Calkins campgrounds who has had some interactions with Jordan Ryder and Parker Page. In her testimony, you will discover three things. First, that the Leckrone Loop, the campsite's most difficult trail, was actually a dangerous trail to hike in. Secondly, that she did not hear any suspicious activity from the hours of 4 to 6. And lastly, that the police officers messed up the investigation when they did not require her official identification. Last but not least, you will hear from Jordan Ryder herself, who will tell you more about the relationship she had with Parker Page and the events surrounding Parker Page's death. Listen closely, as you will find out how loving of a mother Jordan Ryder was to Parker Page and how her death was simply an accident. Jordan Ryder, Parker Page's death was indeed a tragic one and deserves a fair investigation, but only when it is conducted properly and includes all the relevant facts into the case. Members of the jury, my colleagues and I humbly ask that you find Jordan Ryder not guilty of innocent murder to Parker Page. Thank you, Your Honor.
Thank you, counsel. With that being the case, we can go ahead and proceed with the state's first witness if they are ready.
Yes, Your Honor. The state would like to call Detective Chesney to the stand.
Detective, you may take the stand. Remember that you've been constructively pre-sworn.
Yes, Your Honor. Good morning. Would you please introduce yourself to the court?
I am Detective Joey K. Chesney, badge number 7661, lead investigator and law enforcement officer at MCPD.
What is your experience as an MCPD officer, Detective?
I was sworn in 2008. I've been working in the MCPD Major Crime Division since 2016 and completed the Basic Homicide Investigators course 2017. I now investigate major felony crimes in Midland Center like sexual assaults, kidnappings, and homicides.
Did you investigate the death of Parker Page?
Yes, that was my most recent assignment. I led the investigation.
When did you first begin this investigation, Detective?
After I received a call from my supervisor that there was a likely child abduction involving victim Parker Page.
How did you begin your investigation?
I contacted the complainant, Corbin Dallas, Parker Page's legal guardian.
What did Mr. Dallas tell you during this conversation?
Dallas told me that Parker had an illness called brittle bones disease, and he also told me that it was expensive.
After that conversation, Detective, what did you do next in your investigation?
Dallas told, or I found Parker's last known location at Culkin's campground. I headed toward the campground to campsite 12, where I was informed they were by the person at the front desk. However, when I found Ryder was alone.
And how did the defendant react to your presence?
Ryder was nervous and spoke rapidly, including a lot of all that kind of language.
Tell us what happened next, Detective.
About 9 minutes later, I informed other officers and directed them to arrest Ryder for being in violation of her parole. That's also when I patted her down and found a crumpled up napkin in her pocket.
I would like to talk a little bit more about the napkin you just mentioned. Would you be able to recognize it?
Yes, I would.
Your Honor, I will now be sharing my screen to Exhibit 26. Detective, what do you see on screen?
The napkin I found when patting down Ryder.
Is Exhibit 26 in the same condition as when you last saw it?
Yes, it is.
The prosecution now offers Exhibit 26 into evidence.
Any objection from the defense?
No, Your Honor.
So admitted.
Detective, could you please read the circled word in the indicated section on the napkin demonstrated on screen?
Yes, the circle word reads missing.
And Detective, what did the defendant tell you about Parker Page's location on the morning of July 15th?
Ryder told me that she was
Objection,
missing.
Your Honor. Hearsay.
Your Honor, if I may respond.
Yes, you may.
In this situation, this is not hearsay because the detective is quoting the defendant himself and the party opponent rule applies.
Any response to a party opponent exception, counsel?
Yes, I would like to understand as to how the quote in this case is accurate.
Okay, give me a little more there. You're asking how we can know if the quote that the detective is saying is true?
Yes, Your Honor.
Gotcha. I'm going to overrule the hearsay objection then as to the veracity of the quote. If there's another objection you want to offer there, you can feel free to, or you can attack it on cross. I think either way would be an acceptable way of dealing with it, but I'm going to overrule the hearsay for now.
Detective, how did you move forward with your investigation?
I spoke with another camper, Kelly Dews, and she gave me a possible location on Page.
And what did you find, Detective?
Approximately 2 hours later, at 12:30 p.m., we found Parker Page's body under an overlook, 40 feet down. I was surprised to see no trail leading to this area. This led me to believe that Parker had been fallen or had been pushed. And you feel awful for people like her. 40 feet is a big fall for anyone.
Detective, what was the next step in your investigation?
I took Ryder to MCPD headquarters. About 5 hours after finding Page's body, I interrogated her.
Did you ask the defendant about the hiking stick you found in his tent?
Yes, Ryder told me that she was angry that Parker had wanted it.
Detective, did you ask the defendant about the prior day's hike?
Yes, she told me that the Lacrone Loop was steep and uneven. Ryder told me that Parker had tripped and that she was tired and struggling on the hike. She became increasingly angry and told me that Paige was being moody and overly reliant on her stupid stick.
Did you ask the defendant why Parker Page wasn't at the campsite 12 the morning of July 15th?
Yes, I did. Ryder told me that as it was getting dark, Parker had gotten angry and had wandered off.
And Detective, did Parker Page take that walking stick with her?
Ryder told me that she had left it. This was odd because Ryder had just emphasized to me how much she relied on the stick.
What did you ask next, Detective?
I had then asked Ryder about the napkin I found earlier in her pocket.
And how did the defendant react to your questions about this napkin?
Ryder had gotten as nervous as I had ever seen them, especially when I asked about the dollar amounts written near the top of that napkin.
And were these dollar amounts important for your investigation?
Yes. I later found that they matched the insurance policy amount.
Objection, Your Honor.
Of-
Speculation.
All right, give me a bit of an explanation there, counsel.
The witness just stated that Ryder was nervous without an explanation.
Response, counsel.
Yes, Your Honor. The detective stated that the witness was nervous based on his own firsthand experience of the witness's response to the previously asked question, and therefore the speculation is based on his own personal perception.
Okay, I'm going to go ahead and sustain. I think that you can certainly elicit the testimony. Let's just have the detective actually state why he believed them to be nervous instead of just stating that they were. So in other words, testify to some of those perceptions that they perceived.
Yes, Your Honor. And Detective, why were these amounts important for your investigation, going back to the life insurance policy we were just talking about?
The amounts on the napkin match the amounts of Parker Page's life insurance policy.
And would you be able to recognize this life insurance policy today?
Yes, I would.
Your Honor, I would like to share my screen and demonstrate Exhibit 25. Detective, what do you see on screen?
Parker Page's life insurance policy.
And is it in the same condition as when you last saw it?
Yes, it is.
The prosecution now offers Exhibit 25 into evidence.
Any objection from the defense?
No, Your Honor.
So admitted.
Detective, could you please inform the court of the changes the defendant made to this policy?
Yes. At 3:12 a.m. Midland Standard Time on July 15th, 2018, Ryder increased Parker Page's life insurance policy from the $10,000 amount to the $200,000 amount.
Detective, how does this fit into the timeline of your investigation?
Ryder submitted this application hours after Page's estimated time of death, which was between 4 and 6 p.m. on July 14th, as our MCPD forensic pathologist informed me.
Thank you, Detective. No further questions at this time.
Any cross-examination from the defense?
Yes, Your Honor.
You may proceed when ready.
You have been a detective for 10 years, correct?
I have not been a detective for 10 years.
And how long have you been a detective?
I've been investigating homicides since 2016. I had a course in 2017.
Right. So would you say you've performed numerous investigations?
I performed 5 before this one.
On average, a thorough investigation for a case like this would take about 2 to 3 days, would you say?
There are some that take longer than others. It depends on the case.
And evidence such as DNA, footprints, fingerprints, and hair follicles, would you say is all necessary to tie a culprit to a crime scene like this one?
It depends on the circumstances of each investigation. Some is absolutely necessary, others not so much.
So the evidence that you currently have, Detective, can you confidently tie it all to Miss Ryder?
All of the evidence that we have found has tied to Ryder.
Can you state those pieces of evidence that you have?
We found the napkin, which had the dollar amounts of Page's life insurance policy. It listed that on the napkin, it said missing, which was the excuse that I was given. Many other campers informed me of possible locations of where they were the night before, and those all lined up with where we actually found Page's body. And furthermore, the hiking stick was at the tent the next morning. There was many signs to point to it being Ryder rather than any other person who is there.
Okay, I would like to move on. Is it true that you found Parker Page's body on the 15th of July, the same exact day you charged Miss Ryder?
That is the day.
Okay. Can you personally state to the court what you saw when entering the campsite on July 15th?
I went in the campsite. I showed an image of Parker to the person at the front. They informed me that they were staying at campsite 12. So I went to campsite 12 where I found Ryder alone. I found many things from a receipt also scattered around the campsite. I also had logged these into evidence.
So, Detective, when you found Parker Page, no one else was on the trail with her, correct?
No one else was on that trail that day.
And Detective, you didn't find Miss Ryder's footprints or fingerprints around the area in which Parker Page fell, correct?
We did not take any footprints or DNA. We had enough to put Ryder at the area where Page's body was found.
You said you did not collect any footprints or fingerprints. Wouldn't you say that's a part of a thorough investigation, such as one like this?
As I said earlier, it depends on the case. In this case, we had enough to put Ryder at the location without having to do the footprints or DNA because of the other campers and all the details that pointed to it being Ryder.
Detective, there weren't any cameras on the campsite, correct?
There were no cameras at the campsite.
And none of the witnesses you interviewed explicitly told you that they saw Parker Page alone on that trail, correct?
None of them did.
So not only is any of your evidence credible to say that Ms. Ryder murdered her own child, but you also failed to complete a thorough investigation of a crime scene while on the campgrounds by not collecting fingerprints or hair follicles or any type of DNA to suggest or prove that Ms. Ryder murdered her own child. Is that correct?
So with every investigation, I told you it is a different situation per the case. And in this case, we had enough to put Ryder at the scene where we found Page's body. We found everything to put together pieces that pointed to Ryder. There was no other suspect that was likely to be the person who committed this crime.
Okay, Detective. So no one could truthfully say what happened to Parker Page on July 14th at the Chrome Loop correctly.
I mean, obviously Ryder can. However, I don't know exactly what did happen because I never got an answer about that. But everything pointed it to it being with Ryder.
Such as the missing evidence as well, correct?
I feel that we don't have any missing evidence because we had enough to put her at the scene of the crime.
No further questions, Your Honor.
Thank you very much, counsel. Any redirect from the state?
No, Your Honor. Thank you.
All right. Thank you very much, Detective. You may step down. Does the state have any further witnesses they'd like to call at this time?
Yes, Your Honor. We would like to call Kelly Dews to the stand.
Please come on down. And again, remember, you have been constructively pre-sworn. You may proceed when ready as well.
Good afternoon, Miss Dews. Would you please introduce yourself to the court?
Hi, my name is Kelly Dews. I was born and raised in Canada, and I have spent much of my life traveling.
And what do you do for a living, Miss Dews?
See, I would call myself a professional thrill seeker, a social media influencer, and a freelance travel writer, among many other things. Some of my most popular posts on social media have over 20,000 hits. I've traveled across America, from campsites to state parks to anywhere in the great outdoors to find a natural thrill.
And you said you like to travel. Can you tell us where you've been recently?
Of course. Most recently, I went to Culkin's Campground after hearing of it from the TV show Taylor's Top Trails. I really looked up to her when it comes to travel advice, so when my agent put me in touch with her personally, of course I took her advice to go to Culkin's.
And what brought you to Calkins Campground the weekend of July 14th and 15th?
See, I had never been to Midlands before, and I couldn't believe it either, but I was looking for some challenging hiking trails and some beautiful places to feature on my travel Instagram and in my upcoming book.
And what did you do while you were at the campground?
I got to the campsite at around 1 in the afternoon on that Saturday, July 14th, and I had plenty of time to look around, so I checked out some of the trails there. I hiked up and down the Leckrone Loop Trail. I said hi to some campers, checked out Muskie Pond, gorgeous, and I ended up staying the night at Campsite 4. It was a pretty great campground.
And what were the conditions like on the Leckrone Loop?
The Leckrone Loop is definitely one of the harder trails I've been on. It's certainly not for beginners, but for me, I'm great at hiking, so.
And how did you meet the defendant?
Jordan Ryder? I met her on the Leckrone Loop. She was hiking with her daughter, Parker Page.
And when you met the defendant and Parker Page, what did you notice about them?
They both seemed a little on edge. Upon meeting them, Ryder and Parker seemed pretty chill with each other, but after introducing themselves, it seemed to me like they were frustrated with one another. Parker
Objection to speculation, Your Honor. The witness needs rational inference on how Jordan Ryder and Parker Page would seem tensed with each other. So she could just explain that.
Response, counsel.
Your Honor, the witness was not allowed to finish her statement. She was going to explain why she believed that.
All right, we'll let the witness finish the statement, and if we feel that she doesn't actually give any kind of rational inference as to why she believed that they were at odds, then feel free to re-raise your objection, counsel.
May I continue?
Yes.
Thank you. To me, it felt like they were pretty frustrated with each other. Parker seemed pretty upset about hiking because she was limping and she was lagging behind her mother, Jordan Ryder. And it was a hard trail, so I was pretty surprised that Jordan Ryder had picked it, since it was very difficult.
Was Parker struggling with the trail?
Yes, it seemed like she didn't want to be there, but not just because she didn't enjoy hiking like most other kids don't. She was carrying a hiking staff to help with her limp, and she was carrying it the whole time that she was there. She was thrashing tree branches around and poking her mom, Ryder, with the staff. I felt bad that she had to use it the entire time she was on the trail, and I wish that the hike had been easier on her, but it just didn't seem like it.
And how was the defendant treating Parker?
Ryder it seemed to me like Ryder was clearly annoyed that her daughter needed the hiking staff to get up the treacherous Leckrone Loop. Parker's limp looked real, though, so I don't understand why she would be upset about it. Ryder eventually got so annoyed with Parker that she snatched away the hiking staff, almost pulling her to the ground. Ryder then held the hiking staff towards Parker and made a jab towards her hip, which knocked her back. I was shocked because Parker had needed the hiking staff.
And what did you hear between the defendant and Parker Page while they were on the trail?
I heard a few separate arguments. Jordan Ryder had asked me personally if I had been on any of the other trails at the campgrounds, and I told her that she needed to check out the loop near Muskie Pond. It was gorgeous, one of my favorite ponds. And it felt really good to have someone else ask me where good hiking spots are. But Ryder's response threw me off. It wasn't normal.
And how did the defendant respond?
See, all I did was give her hiking advice and tell her where she should go with her daughter. And she told me in response, the way things are going with this kid's attitude, I don't think we're going to get much up this trail. It seemed to me like they were really intense with each other, which was a shame for Parker. She could have totally taken some of the pictures of the trail and gone all the way to the top to get a picture of the peak. That would have been great. If she posted that, she would have gone viral. But it just, she didn't want to be there, it seemed, and Ryder was increasingly annoyed with her daughter and the hiking staff, so I decided to excuse myself after saying hello so that I could continue on my hike.
And was there any more tension or arguing?
Yeah, more than once I heard them getting frustrated with each other again. I heard Parker Page say, I should have just stayed home with Corbin. Whoever Corbin is, I think Parker clearly preferred being with them over being with her mother.
Objection. More prejudicial than probative. What is the importance of Parker wanting to stay with this Corbin?
Response, counsel.
Parker wanting to be with Corbin shows that Parker was at odds with her mother on that day, and that there was clear tension between mother and daughter that was escalating during the hike.
Your response to that, counsel?
Yet it is more prejudicial to state her direct emotions over that rather than the importance of her wanting to maybe stay with someone else that day.
I'm going to go ahead and allow it as it stands. I think there is some probative value in understanding exactly how tense the relationship was getting on the walk itself. If you think that she's testifying to things that fall outside of what she can reasonably know, then feel free to object to that. But for this right now, I'm going to allow it.
Thank you, Your Honor.
Thank you, Your Honor. And while you were hiking that day, did you have any further encounters with the defendant, Ms. Dews?
Not personally. They didn't talk to me anymore, but I did see Jordan Ryder reach for Parker Page's arm with her hand, and after that I saw her motion towards Page's waist with her hiking staff, the one that previously belonged to Parker, not to Ryder.
And what happened after that?
About 15 minutes after I left Jordan and Parker to go eat my lunch, I was close to reaching the summit of Le Grand Loop. I took some pictures. It was beautiful. But it was interrupted because I began to hear a lot of screaming coming from beyond me, right where I left Parker and Jordan. It was alarming.
And who did you hear screaming, and how did you know who it was?
It was Parker Page I heard screaming. There was no way it could have been Jordan. And there was no one else on the trail that day. I had only seen Parker and Jordan, and I had recognized Parker's voice from meeting her earlier. Her voice was unmistakable.
And what was Parker screaming about?
In the middle of just being as loud as possible, screaming, Parker said, "I wish you'd never gotten out of prison," which was shocking. That interaction seemed to turn their relationship pretty hostile, and she even continued to say, "I hate you," to her mom.
And what did the defendant... I'm sorry.
Is there an objection? I couldn't tell. Okay, no, keep going. Feel free to re-ask your question.
And what did the defendant do when Parker screamed?
After the screaming, Ryder grabbed Parker's arm, and the hiking staff that was taken earlier was now near Parker's collarbone. After that, about 15 minutes after the fighting had stopped, I made my way back to the campground for the night. I didn't want to get in the middle of it. I didn't want to be down there while they were fighting, so I just went down afterwards.
And did you see the defendant or the victim again while you were there?
No, I didn't see anyone at the spot where the scream had come from. I went down there to check just to see if anything had happened, if anyone was still on the trail, but there was no one there. When I did get back to the campgrounds, though, I saw Ryder with a red pickup truck, but not Parker Page. The last time I saw Parker was when she was screaming, when Jordan grabbed her arm and held the hiking staff in front of her collarbone. I found it kind of strange, but I was also preoccupied with some writing for my travel blog and editing the pictures that I had taken on my hike. So I didn't think too much of the fact that I didn't see Parker again after that hike.
Thank you, Ms. Dews. That will be all, Your Honor.
Thank you.
Cross-examination from the defense.
Yes, Your Honor.
You may proceed when ready.
So, Kelly Dews, you work in the social media business?
Yes, I do.
On MeTube?
Yeah.
And you often do dangerous stunts for this MeTube, correct?
Yes, I do. Oh my gosh. Can I let you in on a secret? This is from one of the places that I visited. I got arrested after, but I took the sign and it was great.
Now, in your first encounters with Jordan and Parker, you saw Parker and Jordan sharing a disagreement, correct?
Yes.
And you saw a hiking stick during this time period with Parker and Jordan?
Yes, I did.
Parker poked Jordan with that hiking stick?
Yes. Parker poked her repeatedly in the calf.
So about Parker Page, you saw Parker Page while she was hiking.
Yes, I did.
She seemed like a preteen.
Yeah, no older than 13. She seemed young.
Fragile.
Yeah, I felt really bad for her limp.
And you saw her limping.
Yes, I did.
Now let's talk about those trails you were on. Were those trails, did they look steep?
They did, and the trails are really narrow. You couldn't walk side by side, so Jordan and Parker had to walk front and behind each other.
With high drop-offs?
Yes, I think so. There were multiple peaks of the trail that you could go to, but I didn't see all of them.
In fact, you thought those trails were hard?
Yeah, it was difficult for me, but not impossible. I've been hiking forever, and I'm really good at it.
Okay. And about that hike, you walked back and you said you saw Jordan and Parker still in the same spot as their first encounter, right?
When is this exactly?
Did you say that after you saw them for the first time and you were on your way back to the Lacron Loop Trail, did you see them in the same spot as they were?
Yes. Before I went up to Calkins Rock, it had been almost an hour. I was just walking around the trail. I looked back just to see how far they had gotten, because I know that Parker was kind of slow, and they hadn't moved in nearly an hour.
So would you say Jordan didn't make Parker walk along any further than the last time you saw them?
I'm not sure. I didn't watch them on their entire hike. I was pretty busy taking pictures of my own, but they seemed to be pretty slow along the trail.
Now, you said you heard a scream when you were going on your way back to the Lacron Loop.
Yes, I did.
And there was no one you saw when you heard the scream.
No, I didn't see. It was wooded. There were trees around me.
And you did not see Parker Page?
No. I saw Parker Page after the fact, after she had stopped screaming when Jordan had grabbed her arm, but I didn't see Parker while the screaming was happening.
And you did not see Jordan?
I saw Jordan after the trail, after I had gone off the trail back at the campgrounds.
My apologies. I meant you did not see Jordan when the scream occurred.
No, I did not.
And when Parker was deemed missing, you were actually in the search party to find Parker's body?
Yes, that's true. Detective Chesney came up to me and asked if I had known of a possible location that Parker could be at, and I recalled the last place that I had saw her.
And the police officers did not have Jordan with them searching when you were on there?
No, I didn't. Jordan was not part of the search party. I didn't interact with Jordan at all after that.
And when discovering the tragic sentence of her body, you saw her pronounced dead?
I didn't see her, but I heard the official declaration that she was dead. It was shocking. I was really upset.
Okay, and it had still been less than 24 hours since her disappearance, correct?
Yeah, it was the next morning.
And when the police officers discovered Parker's body, they accused Jordan Ryder?
Yeah, I heard them talking about, I can't believe Jordan would do this. I can't believe Ryder had killed her kid. I didn't know why they were making those accusations. I didn't know if it was official or not.
And about that officialness, another said that Jordan never should have gotten out of jail.
Yes, that's true.
No further questions, Your Honor.
Thank you.
Any redirect from the state?
No, Your Honor.
Thank you very much. This witness may step down. Does the state have any further witnesses they'd like to present at this time?
No, Your Honor.
All right. With that being the case, I guess the bailiff can direct me here. Is the state going to rest its case in chief now?
Yes, they are.
Okay. Are we going to give them time for a quick break, or are we supposed to keep rolling straight through?
We've got time. They can take a break, like 5 minutes.
I love it. Yeah, let's go ahead and do that.
Sounds good. So I'm going to open up the breakout rooms. I have everyone assigned for prosecution and for defense. I'll set a timer for 5 minutes, and I'll close the rooms down like 12:36. So everyone's back in here by 12:37. All right, the breakout rooms are closed.
All right, we should have everyone here. So let's go ahead. Does the defense have a witness they would like to present to begin their case in chief?
Yes, Your Honor. We would like to bring forth Ms. Cameron Lee, the first witness of our defensive case today.
Absolutely. Remember, again, you've been constructively pre-sworn. You may proceed when ready, counsel.
Good morning. Could you please introduce yourself to the members of the jury?
Morning. My name is Cameron Lee.
Now, Cameron Lee, what do you do for a living?
Well, I currently work for a bondsman, but camping takes up most of my time. My favorite place to go is the Calkins campground. I've been going ever since I was a kid. I've made so many memories there, met so many different people.
So, when was the last time you remember camping at Calkins?
Well, I was there the weekend from the July 13th to the 15th, the weekend that Parker Page tragically died.
Could you please describe why you camped at Calkins campgrounds on that particular weekend?
Yeah, so like I said, camping takes up most of my free time. I absolutely love camping. And I had a business trip to go on that Sunday. So on the Friday, I went straight from work to the campground so that I could get in some extra camping before I left.
So, seeing that you have been familiar with Calkins campgrounds for a while now, what is the environment like at Calkins?
Well, I know every bit of the campground. Like I said, I've been going there all my life. It's my favorite thing to do, and I kind of see myself as an expert camper. But I know that for someone who rarely goes, that some of the trails can be really hard to navigate and hard to walk on. But for the most part, the environment is great.
Are there any trails in particular that prove to be difficult?
Yes, actually, the Lake Roan Loop. It's one of the hardest trails in the state, and even I can attest to that. Every time I try and climb the trail, I always get kind of discouraged and give up halfway.
Now, Miss Cameron Lee, I would now like to talk about how you spent your weekend at the campgrounds. What was your morning like on July 14th?
Well, first, I woke up. I went on a walk around the river to collect some more wood for my campfire, and I saw two people. Or I'm sorry. After that, I made some breakfast, got ready for the day, and went on a quick hike. And then I ate some lunch.
When did you first meet Jordan Ryder and Parker Page?
It was around 2:30, 2:45. When I was going to eat my lunch at a picnic spot, I saw two people walking towards me, and it was them. So then we had a short conversation.
What was that first interaction like?
Well, first I saw them arrive in this really loud red Chevy truck. And the muffler was like broken or something. It needed to be fixed so bad. It was so loud. So that's how I remember it. And then I heard the couple inside the truck arguing. And it was about the radio, and I saw a little girl. So I waved at her, and she was the only one who waved back. But when I actually talked to them, Jordan Ryder was the only one who spoke, and he seemed pretty friendly, but he kept the conversation really, really short. Like every time I tried to engage with either of them, he kind of quickly ended it.
When was the next time you saw Jordan Ryder and Parker Page again at the Calkins campgrounds?
It was around 4:30. I saw Jordan and Parker walking back to the campsite on the bridge. Parker was lagging behind, but that was the last time I saw them while I was there.
Around the hours of 4 to 6 p.m., did you hear or see anything suspicious?
No, nothing weird occurred to me. I feel like it would have been easy to tell if something was happening, but from my standpoint, there was nothing going on.
So, going into a Sunday morning, how did you spend your morning at the campgrounds?
Well, Sunday was the day I had to leave and go to the airport, so I packed up my tent and I went straight there.
Where did you go on that Sunday?
Well, that was my business trip. It was pretty fun. I went with the bondsman that I work for, and after I returned to the Midlands airport on Saturday, July 21st.
So, during your business trip, did you hear anything about Parker Page's death at the Calkins campgrounds?
No, I didn't hear anything at all.
So, how did you eventually discover about her death?
So the day that I was coming back, I was at the Midlands airport and I stopped to get some coffee, and I saw this story about Jordan and Parker on the TV in the coffee shop, and I couldn't believe what I was seeing. I didn't know anything was happening when I was at the camp. Um, I just was so shocked.
So seeing that you saw the news, what did you do as you got out of the airport?
I called 911 and a taxi took me to the police station, and it was Detective Chesney, the officer at the time. He questioned me and he asked me like a lot of questions, and I answered as best as I could.
What was that first day of the interrogation process like?
The first day was pretty straightforward. I was just speaking with Detective Chesney the whole time, and he actually called me back for a second day.
How was that second day?
It was kind of a weird experience. There were a lot of reporters, and then they took me to this really big back room. And then they even told me that I had to provide ID, but then later they told me that it wasn't necessary, so they didn't take it.
Do you know why they did not need any official identification?
No, I was really confused. I thought that was weird.
No further questions, Your Honor.
Thank you very much, counsel. Is there any cross-examination from the state?
Yes, Your Honor.
You may proceed when ready.
Good afternoon, Miss Lee. How are you?
I'm doing well. How are you?
I'm well. As I understand it, you've been hiking for years at the Calkins campground, correct?
Yes, that's right.
And as a longtime hiker, you've struggled with the Lacroix Loop.
Yeah, it's not my favorite trail to go hike on.
And when you met Parker Page, she had her hiking stick with her, correct?
She did. It looked like it was really helping her with her limp, I guess.
And you recognized Parker's clothing.
Yes, I did.
And if you had met Parker again, would you have recognized her?
I would have, because she was kind of the only one that seemed like she was sweet when I met her, even though she didn't speak much.
Okay. And did you see any other hikers on the trail that day?
No, I didn't, just the two of them.
And did you see the defendant return?
Yes. When they were walking back to the campsite on the bridge.
Did the defendant have anything with her?
No, she didn't.
In your affidavit, you stated that the defendant was carrying the Parker's hiking stick that you had recognized from earlier when you met the two.
Oh, were we talking about Jordan? Sorry. Then yes.
Yes, the defendant.
Yes.
So the defendant had Parker's hiking stick with her.
Yes.
When you saw Jordan Ryder returning across the bridge, did you see Parker?
I did see Parker about 10 minutes later. She was kind of like really far back from where her mom was.
In your affidavit in line 103 and 104, you stated that you were not sure who you saw returning and that you were not, and that nobody was with Parker and that the person you saw returning was walking alone. Is that correct?
That is correct, but there was also no one else on the trail that day. So my assumption was that it could have only been Parker. And because she was kind of physically impaired and had the limp, I heard like dragging, like she was dragging her feet. So it could have really only been her.
I believe you stated that you saw Mrs. Dews on the trail that day.
I'm not sure.
Yes, about 2 minutes ago, you stated that you saw Miss Dews on the trail that day. So you never saw Parker return.
I believe that I did see Parker return, yes.
You did not recognize them, their clothing. You did not hear them say anything, correct?
Correct.
So 10 minutes after the defendant returned, you saw somebody else return, and that is the only person you saw return from the trail that day, besides the defendant.
I heard Parker return because of she was dragging her feet, and then I saw Jordan first, and then I saw Parker, or I heard Parker. I'm sorry.
But you can't be 100% sure that it was Parker. You never saw them. You never heard them. There was nothing identifying about them that you recognized, correct?
She had to be the only one on the trail that day, like the only one left on that trail. And I said before, like, she dragged her feet because she had a hard time walking. So it was her.
So you are not 100% sure that it was Parker. It could have been Miss Dews.
No, I don't think so.
And you only ever saw one person besides the defendant return.
Right.
Okay. And after your first introduction to Parker, you never saw Parker again with you.
After my first introduction. Well, I saw Parker a few different times. I saw Parker in the red Chevy truck, and then I saw them when her and her mother came over and spoke to me.
But after that introduction, when you spoke to her, you never saw her again, correct?
Correct.
And during that night, were you ever awoken?
I heard the muffler on the red Chevy truck that was really loud. And I woke up around 2:30. And I remember kind of being annoyed because it was really loud and I was trying to sleep. But yeah.
Okay, so at 2:30 a.m., you were awoken by the headlights of the same red Chevy with the missing muffler that you had seen the defendant driving before, correct?
Correct.
And at 2:30 a.m., you saw the defendant's car leave Calkins Campground, correct?
Yes, I did.
That will be all, Your Honor.
Thank you very much. Is there any redirect from the defense?
No redirect, Your Honor.
Excellent. Thank you very much. The witness may step down. Does the defense have any further witnesses they'd like to call?
Yes, Your Honor. We'd like to call Jordan Ryder to the stand.
Jordan Ryder, come down, and again, you've been constructively pre-sworn.
Can you state your name for the jury, please?
Jordan Parker Ryder.
And can you tell the jury about your relationship with your daughter?
Yes, of course. Parker was my entire world. Her father and I had been wanting a child for a long time, and we struggled for months. Parker was a miracle for the both of us.
And where's the father now, Miss Ryder?
He passed away just when Parker was about 3 from aneurysm.
How did your daughter Parker take the death?
Not lightly at all. Neither of us did. It was just us 3, and when her father died, we only had each other.
Objection, relevance.
Response, counsel.
The reason this question is relevant is because it's going to later be brought up about Parker's behavior with her father and her mother.
Any response to that?
Thank you, Your Honor. Why is the reaction of Parker's response to her father's death relevant to this case when we're discussing the murder trial of Jordan Ryder?
Because it shows the relationship between them.
Any response to that, counsel?
No, Your Honor.
All right, relevance is a low bar, so I'm going to allow it. If you feel, though, that it doesn't add anything substantive to the trial, you can feel free to re-raise later, but I'll allow for now.
May I continue?
Yes, you may.
So, Parker has a condition, brittle bone disease. Can you tell us more about it?
Yes, in 2013, she was diagnosed with it. I'm no doctor, so all I know is that Parker's bones were a lot more fragile than the other kids.
Did Parker have any other conditions prior to being diagnosed with brittle bone disease?
Yes, actually, she had asthma. It runs in the family.
How did Parker take the news about her new condition, Ms. Ryder?
Not lightly at all. It really made it awful. And she was so scared of what could happen to her if she went outside. She never left the house, let alone her room. It upset me greatly to see her like that. We stopped going on our adventures because she was too afraid of what could potentially happen to her.
And what did you do as a mother to support her during this hard time, Ms. Ryder?
I still encouraged her to go outside, to not be afraid, basically, and embrace her condition. I would suggest we go out for walks around the corner for ice cream, taking it little by little until she gets back comfortable with going out.
Is that when you suggested that you guys go to Camp Calkins?
Yes, we always talked about it and made up stories about what it would be like to go hiking at the Lacrone Loop. Parker used to draw pictures of her standing on the trails. She was smiling so hard, so I wanted to make it happen.
Ms. Ryder, I'd like to go into more depth about the day of July 14th, 2018. Can you tell me what you remember?
I was on the Lacrone Loop, the campsite I just mentioned.
And were you accompanied by anyone?
Yes, my darling daughter Parker came with me on this trail.
And what were you guys doing there, Ms. Ryder?
I wanted to show Parker that she could be strong, so we hiked the trail together. We both love trails and hiking, so I thought Lacrone Loop would be exciting for the both of us and give Parker an opportunity to live again.
And how did Parker feel about going on the hike?
She was excited, but it looked like something was still bothering her. I asked her if something was wrong. She said she was fine, as any other teen would say, so I didn't pressure her into saying anything. The car ride over to the campsite was great. We listened to our playlist we made together about a year ago, lots of smiling and laughing. But it took a turn once we got closer to the campsite. I could tell Parker was upset, so I asked if everything was okay.
And what did she tell you?
She was feeling down about her father. She missed him, and going hiking without him just didn't feel right. So I pulled over to the side of the road so that we could talk. She just kept telling me about how much she wished her father could have been there with us. I didn't know any right words to say at the time, so I just gave her a big hug and told her, "He is always going to be with us," and pointed at the necklace around her neck.
Objection, hearsay.
Response, counsel?
The witness is not explicitly telling us what Parker said in quotations. She's giving a brief explanation of what the conversation was like between the two of them.
Response, counsel?
Yes, Your Honor. However, she is still providing outside information. It sounds like if she is taking it for truth.
And one last response, then I'll make a ruling.
Again, the witness is providing a non-quoted explanation of the conversation with her daughter during the time of which they were heading to the campsite.
All right, if we're saying that this isn't a direct statement, then I'll overrule and allow and instruct the jury that this is not a direct representation of the conversation, but a retelling of what the contents of it were. However, counsel, if you think that there is any kind of direct quotations that are being elicited, feel free to re-raise that a hearsay objection, and then, okay?
Okay.
You may proceed, yes.
So you talked about a necklace, Miss Ryder. Can you tell us more about that?
Yes. Her father made a necklace before he passed away with a socket picture of the three of us hiking when Parker was 4. She hasn't taken it off ever since. It held great weight to Parker.
Thank you, Miss Ryder. So around what time was it when you and Parker had settled into the campsite?
It was around 12 p.m. when we set up our tent. Parker was so excited to start the trail, so we started right away. We had walked a bit of the Lacrone Loop and headed back to our tent by 4 p.m.
So do you remember what your whereabouts were around 4 to 6 p.m.?
I was in the tent.
And were you aware that Parker had left the room between those times?
Yes. She told me she was going to go down to the bottom of the lake to play with the frogs in the pond. I said okay and told her to be back before dark. I never in a million years imagined she wouldn't return to me. Sorry.
No, you're fine. Miss Ryder, can you tell me what you were doing while she was gone at the lake?
I took a nap. I was a little winded from the hike we did earlier, and I knew that Parker would probably be hungry after our huge hike, so I got up and made Parker's favorite chicken Alfredo to surprise her.
So around what time would you say you got concerned that Parker hadn't returned back to the campsite from the lake?
It was about 9:30 p.m. I had finished dinner and noticed it was pretty late for Parker to still be out, so I went out looking for her. I searched most of the night for Parker, but to no avail.
So at any point during that time, did you think Parker was in danger or that maybe you should call the police, Miss Ryder?
I became increasingly worried for Parker after I couldn't find her, after searching for so many hours. After I started stumbling over my own feet and having many close calls of falling over the edge myself, I reluctantly decided it wouldn't do Parker or me any good if I couldn't have my full attention on finding her. So I returned to the tent with plans for a quick nap before searching again for my daughter. It didn't even occur to me to call the police. I suppose I was just so panicked at the moment that I forgot everything else and focused on finding my daughter as soon as possible.
And can you walk me through the following day, Miss Ryder?
I woke up to a police officer, Detective Chesney, I believe. She asked me a couple of questions about my daughter Parker and if I knew her current whereabouts. I told them everything that I just told you about the last night, and she had gone out and never returned. I told them that I went out myself to look for her, but the trail was too dangerous for me to walk on late at night.
And what happened after you talked to Detective Chesney?
A couple hours passed by. She told me she was going out with her team to look for Parker and that I should stay in the tent until she returned. She told the police officer to keep watch of me and while they went out.
And about what time would you say Detective Chesney came back up to the campsite?
Around noon.
And did they ever find your daughter?
Yes, they found my daughter dead at the bottom of the Crone Loop. After that, my world just seemed to crash. Parker was my whole world. Knowing that she was gone just shook me to the core. I was devastated that such a thing had happened, but I was also furious with myself. Why hadn't I noticed sooner? Why was I foolish enough to forget to call the police? I just wish I had a chance to start over, to make things anew. Now, that chance is gone.
No further questions, Your Honor.
Thank you very much. Is there a cross-examination from the state?
Yes, Your Honor.
You may proceed when ready.
Thank you, Your Honor. You, Parker, and Corbin exchanged letters during your imprisonment?
Yes, that is correct.
Updated each other about what's happening?
Yes, we usually exchange letters about how Parker was doing or how I could improve better to be a better parent.
Sometimes you would call her my superhero girl?
Yes, our superhero stories were always amazing. We would joke about how she was the superhero, I was the sidekick, and we would write stories in our letters to encourage each other.
And you continue the stories of the superheroes, correct?
Yes.
In these stories, it would only be you two?
Yes, we always had lots of fun with them. It was also a way to encourage Parker to be stronger.
Both going on adventures exploring the wilderness?
Yes.
I'll now be presenting Exhibit 11. What do you see on screen?
That is one of the letters that I wrote during my time in custody.
Has this document changed from the last time you've seen it?
No.
The prosecution now offers Exhibit 11 as evidence.
Any objections?
No, Your Honor.
All right, so omitted.
Please read the third mini paragraph from When to Stories.
When I get out, we will go on great adventures together. I promise. It will be just like in our stories. Treasure hunts and climbing up mountains. Nothing and no one will keep us apart once I'm out.
Parker could freely move around in these stories, correct?
Yes.
And not really getting hurt?
No.
But these were just stories to keep her brave?
These were stories to keep her brave, but it was also a hope for the future.
And you made a promise upon your release that she would never get hurt as long as you were there.
I made a promise that I would do the very best that I could to protect her.
But in real life, she could get hurt?
Yes, no one can make a true promise to ever get hurt, only that they can do the best of their abilities to protect, just like a mother using her fierce protection to protect her daughter.
So it's safe to say you were very aware of your daughter's condition, brittle bones disease.
Yes.
You spoke to Detective Chesney about the murder of your daughter?
I did.
And you believed Corbin's place just wasn't safe?
It was not safe. Every letter she wrote me just reeked of alcohol, and there were glass bottles on the floor. It was not safe at all for Corbin to watch over Parker.
So she could easily get hurt from a fall?
Yes.
And you wanted your daughter to be in the best hands, you being number one candidate?
I did.
Do you then believe you can easily determine what is safe or isn't safe for your daughter?
Yes.
Is it fair to say you at least had general knowledge about her condition?
Yes.
You received a letter from Corbin containing information about brittle bones disease?
I did. It was really disturbing. I had hoped that Corbin would be able to do the best of her ability to keep my daughter safe.
I'll now be presenting Exhibit 10C. What do you see on screen, Ms. Ryder?
I see a report on osteogenesis imperfecta.
Is Exhibit 10C the same condition as when you last saw it?
Yes.
The prosecution now offers Exhibit 10C into evidence.
Any objection?
No, Your Honor.
So omitted.
Do you recognize the symptoms of brittle bones disease?
I do.
So you recognize a symptom includes weakened bones,
Does.
muscle weakness,
Yes.
and a minor fall can result in a fracture
Yes.
or possible surgery.
That is true.
And there are treatments, correct?
I believe so.
Are you aware of these treatments?
Not entirely.
I'll be scrolling down on this to show the treatments. And I'll also be later quoting them as well. Do you see the second to last paragraph that says other treatments and focus on OI-related symptoms include?
Yes.
Could you read out those 4 bullet points?
Hearing aids, crowns for brittle disease, supplemental oxygen for people with breathing problems, and mobility aids such as walkers, crutches, canes, and wheelchairs.
You and Parker went shopping earlier on July 14th for supplies, correct?
Yes.
And you reluctantly purchased a hiking stick?
I did. I knew that even though I wanted Parker to get stronger, it was good to have some safe item for her to hold on to.
And to you, she wanted that hiking stick?
Yes, I knew that it would be good to have some support for her.
And you know the purpose of a hiking stick?
I do.
And to be clear, you did not want to originally purchase this hiking stick?
I was slightly reluctant, but overall, I knew that it would be best.
This resulted in a slight argument between you and your daughter?
It did.
Sometime later on July 14th, you and Parker were hiking on the Lecron Loop?
Yes.
Lecron Loop has an even ground.
It does.
It's steep.
It is steep.
Sudden drop-offs.
Yes, but I knew that I would be able to protect her as long as we stayed close to each other.
And you just wanted to spend time with your daughter?
Yes, I wanted to keep that promise to her that we would go out on adventures again, like I had wrote in the letters.
After a certain point, she was lagging behind.
That is true.
You believe she was giving up like she always does, in your words?
She does tend to be more reluctant on certain things, but I do know that when she needs to be, she can be very perseverant.
She might have been hurt,
Maybe.
but you tried to help her,
Yes, this is why I bought the hiking stick.
and she started complaining.
She did.
You were somewhat hurt by those words?
A little bit. I knew we both had great hopes to go on adventures together, and I didn't want her to simply back out on those, knowing that she had been so excited.
So to help, in your words, you took the stupid stick.
I did.
And you never purposely hurt Parker.
No, I would never purposely hurt Parker.
At first, you thought she wasn't hurt that bad.
Yes,
And in talking with Detective Chesney, you said she wasn't hurt at all.
I did.
So do you believe she was hurt?
Perhaps a little bit. I was really just so stressed about the moment that my mind seemed to fog.
And Parker had life insurance.
She did.
And was originally for $10,000.
It was.
I'll now be presenting Exhibit 25. What do you see on screen?
This is the life insurance policy?
Has the condition changed at all from when you've last seen it?
No.
The prosecution now offers Exhibit 25 into evidence.
Any objection from the defense?
No, Your Honor.
So admitted.
Ms. Ryder, could you please read from 10:42 a.m. all the way to Jordan Ryder, this section right here?
Yes. 10:42 a.m. Midland Standard Time to July 14th, 2018. And the application submitted time was 3:12 a.m. Midland Standard Time and July 15th, 2018. And the new renewal or increase application is increase request. The current policy was 10,000 basic burial and insured was Parker Page, DOB 31506, and the policy holder is myself, Jordan Ryder.
So to be clear, you raised the dollar amount on July 14th at 10:42 a.m.
I did.
And you increased it to the highest amount as indicated on the sheet?
Yes, I did. Corbin and I both discussed this about a month or so ago after I had gotten out of prison. We both knew of her brittle disease and we had both been increasingly worried. And if the worst were to come, and I never imagined that it would, we needed to make sure that we had the money for Parker to have the funeral she deserved.
And at the time of your release, you really didn't have money saved up?
No.
In your words, it sounded like a good amount.
It did sound like a good amount.
Thank you, Your Honor. No further questions.
Any redirect from the defense?
No, Your Honor.
Are there any further witnesses from the defense at this time?
No, Your Honor.
All right. With that being the case, does the defense rest its case in chief?
Yes.
Excellent. Closing arguments are up next. Are we ready to proceed, or do we want to take a brief break to prepare for them?
We would like to take a recess, Your Honor.
Okay. I'm assuming we have time. The bailiff can direct me there. I'm sure 5 minutes might be all right, though.
Yeah, we've got time. We'll do 5 minutes, just like beforehand. I'll open up the rooms. You'll have from 1:12 to 1:17. Rooms will close at 1:16, so we can start at then. Sounds good?
Perfect. Thank you.
Sounds good. All right. Rooms are now open.
All right, looks like we've got everyone back. So if the state is ready and would like to proceed with presenting a closing argument, they may when they're ready.
Yes, Your Honor. May it please the court. The defendant has shown you that when tough love gets too rough, emotions escalate and things get out of control. When tough love gets too rough, the defendant murdered Parker Page. The defense tried to tell you that the defendant loved Parker more than anything, that she would have done anything to keep her illness from affecting her too much. The defense then tried to blame Detective Chesney, even though he expertly told you that he had enough evidence to arrest the defendant. The defense even called the defendant's actions against Parker Page innocent murder. But members of the jury, the murder of a 12-year-old girl is anything but innocent. So let me tell you what really happened. On the afternoon of July 14th, the defendant walked up the steep and treacherous trails of Lacrone Loop as a tired and injured Parker Page staggered behind. Parker, who was completely reliant on her walking stick, made it up the seemingly impossible trail, but she was terrified of falling. She knew the limitations of her condition, brittle bones disease, and so she begged, she pleaded with her mother to turn back. Our defendant was convinced otherwise, so she practically forced Parker Page up the trail. With each second of hearing Parker's pleas, the defendant's blood boiled until finally, in total rage, the defendant yanked the hiking stick from Parker's fragile hands and shoved her off a cliff. Parker's body fell 40 feet down that day. And why? Because the defendant's tough love got too rough. As a part of the prosecution today, it is my job to prove to you, members of the jury, that the defendant murdered her daughter, Parker Page, beyond any reasonable doubt. We have laid out all the evidence necessary, so you must let each testimony, each exhibit, and each quote serve like a stepping stone, leading you to the only reasonable conclusion, that Parker Page is a murderer. The defense will try to make our burden of proof seem unattainable, but there is an abundance of reasonable evidence to prove that she is guilty. So allow me to walk you along the stepping stones we have laid out. You heard today from Detective Chesney, who told us that when he arrived at campsite 12, hoping to find Parker Page and the defendant, he only found the defendant asleep and alone. "Where is Parker Page?" he asked. The defendant told Detective Chesney that she had wandered off the night before. The detective told you that this made him suspicious because he knew Parker Page was fragile and extremely dependent on her walking stick. But for some reason, the detective found Parker Page's hiking stick in the defendant's tent. Something wasn't adding up, members of the jury. Chesney also told you that he found Parker Page's body at the bottom of a 40-foot cliff on July 15th, and he noticed something. There was no trail leading to the area where Parker Page was found. He told you that this made him think Parker had fallen, because how else would she get there, especially without her walking stick? Think about it. The only reasonable answer is that she was pushed by the defendant from the top of the cliff. You then heard that the napkin the detective found, and it made the defendant feel incredibly incriminated. Now, why would that be? What could be on that napkin that made him feel this way? There are two answers to this question, ladies and gentlemen. First, the 4 lines the defendant wrote on the napkin. The first 3 she crossed out, but the 4th, that final word, she circled, and that word reads missing. Now remember what the excuse was that for not knowing Parker's location? That she was missing. To lay down another stepping stone for you, members of the jury, the napkin is a snapshot of the defendant's thoughts while she decided that the most strategic excuse for murdering Parker was to say she was just missing. The second part of the napkin that incriminates the defendant are the dollar amounts. The detective told us that the dollar amounts were a perfect match to those on Parker Page's life insurance. Now you might ask yourselves why this is important. The defendant submitted the change on Parker Page's life insurance policy statement at 3:12 a.m. on July 15th, hours after Parker Page's estimated time of death, which was between 4 and 6 p.m. on July 14th. And the change that was made, the defendant increased Parker Page's life insurance from $10,000 to $200,000. Now, why would a scared parent looking for their missing child make such a change? The answer is simple. They wouldn't. Only a murderer looking to profit from their own child's death would do such a thing. And that is exactly what our defendant is. Jordan Ryder is a murderer. Members of the jury, you then heard from Kelly Dews, who told you that she saw with her own 2 eyes a limping Parker Page arguing with the defendant, verbally and physically. Ms. Dews told you that she saw the defendant try and yank the hiking stick away from Parker Page, a hiking staff that Parker needed to feel safe and comfortable. Yet the defendant, overtaken by her anger, confiscated the one and only thing giving Parker Page any comfort that day. You also heard Ms. Dews tell you that a mere 15 minutes after seeing and hearing the defendant and Parker fight, she heard a loud yelp. A yelp which she told you was unmistakably Parker Page's. What happened? Ms. Dews heard Parker's last words. As she fell 40 feet down, Parker Page's yelp was one of heartbreak and shock. Helpless, Parker was pushed to her death. And what did the defendant, Parker's murderer, do? She went back to her tent with Parker's hiking staff, changed Parker's life insurance policy to make sure her actions were worthwhile, decided to tell the police Parker was missing, and then she went to sleep. The defendant's carefully planned actions after murdering Parker reveal that she knows her wrongs. She knows she is a murderer. Members of the jury, you must find the defendant, Jordan Ryder, guilty of aggravated murder, which is the murder of a victim under the age of 13. Parker Page, the victim of the defendant's tough love, was only 12. So members of the jury, I implore you to take the bold actions Parker Page deserves. By following the stepping stones that are so clearly laid out in front of you, members of the jury, you must convict Jordan Ryder guilty of aggravated murder beyond any reasonable doubt. Thank you.
Thank you. Any closing statement from the defense?
Yes, Your Honor.
You may proceed when ready.
May it please the court. Here stood a loving mother with nothing but tears that contributed to the scene we saw today. Having nothing but a few seconds to take in your daughter's cold, dead body being described before you by the officers was all Jordan Ryder got before being hogged down and questioned by the police as their first suspect, even before gathering all the evidence they could. It hadn't even passed 24 hours before Jordan whispered the last words she would ever get to say to her daughter again. I love you. As Parker Page went off into the darkness and left Jordan Ryder in that tent. Jordan just wanted her daughter to see how strong she could be, for Parker to get out of her comfort zone that was filled with fear. But Jordan knew what her strong girl could do, how brave she was. She wanted Parker to escape her old home with Corbin, who brought alcohol-infested bottles as a danger to Parker everywhere. Parker was the last piece of Jordan's family. Jordan couldn't afford to lose one more person in her life. In fact, she held the fear of the outcome we're all here today for. The state has the burden to prove to you that Jordan Ryder committed the crime of aggravated murder against Parker Page without any reasonable doubt from you. And by reasonable doubt, it means that by the time the prosecution closes their case, there must be no uncertainty in your mind that Jordan Ryder killed Parker Page. The state had to prove to you that A, Jordan Ryder used physical force to push her daughter off a Lacrone Trail, which caused Parker Page to fall to her death, and B, that Jordan did it knowingly. However, it has been made clear by the state's case today that even with their testimonies and evidence they claim to have for you today, they did not prove that Jordan Ryder murdered Parker Page. The state did not have any eyewitnesses. Nobody saw Jordan Ryder leave Lacrone Loop without Parker Page. Nobody saw Jordan Ryder push Parker Page. Nobody saw Parker Page get pushed off that cliff. There was no usable DNA evidence whatsoever to be found on Parker Page or her hiking stick. No usable fingerprints or tracking. Kelly Dews did not see who screamed, and no hunch of hers or the prosecution can change that. And you heard today that Parker Page yelled, "I wish you'd never gotten out of prison," at Jordan Ryder. However, when a preteen is in a fight with her mom, she's going to deliberately say words that will be sure to hurt her mom the most, especially when protesting the hike. Because Parker didn't want to hike, she clearly wanted to be at home in the moment and she stayed home a lot when Ryder was in prison. Families fight, but one fight on one day does not automatically lead to any signs of any murder. Preteens act out more as they are claiming their independence, especially a 12-year-old with brittle bone disease that doesn't want to be reminded of her illness when hiking. So later, Parker ran away to find her father's special necklace without telling Jordan. Now, here's what you did get proven today. Cameron Lee and Kelly Deuce testified before you today that they are both hikers with the experience of dangerousness and of the Midlands Lacroix Loop hiking trail. Both said how steep and dangerous the trails were even for them as healthy hikers, and Cameron Lee is an experienced one. So for an 80-pound, 12-year-old girl with brittle bone disease and severe asthma, Parker could have easily tripped over a single rock and died. Jordan couldn't have made Parker walk any path more than she could do. In fact, Kelly Deuce from the state even told you today that they stayed in the exact same spot as she saw for an hour. Members of the jury, it's not unreasonable to see how Parker Page could have fallen off that cliff when Parker left Jordan sleeping to get her father's special necklace she lost. Jordan even searched all night for her in a panic. Cameron proved that Jordan Ryder and Parker Page did leave the Lacroix Loop together. Although prosecution tried to show that Cameron claims to have only heard someone trailing directly behind Jordan, when it comes to all the facts in this case, really, who else could have been lagging behind Jordan besides his own daughter she went hiking with? We know it had to be Parker Page that Cameron heard right behind Jordan, because since Parker was complaining a lot during the trail, the couple had to leave the trail early. And with Parker's hiking stick and slow pacing, even Cameron Lee was sure it was Parker Page. You heard there were no eyewitnesses, DNA evidence, or footprint tracking. Yet, two of the police officers on Detective Chesney's team accused Jordan Ryder of being the culprit right when the body was found, before all the testimony was gathered for this investigation. One officer stated they couldn't believe Jordan Ryder did this. Detective Chesney led this bias to the country, not even including Jordan in the search party for her own daughter. And not even a week later, Cameron Lee saw Jordan Ryder and Parker Page plastered all over the news channel. Cameron Lee immediately alerted the authorities on Chesney's team in an attempt to get his side of the story out there. But the police were so absorbed in their bias against Jordan Ryder, they just shoved Cameron into a large back room, saying there was no need for official identification. Yeah, no need for official protocol by the state when you already see Jordan guilty. The police weren't even going to bother looking for any other suspect besides Jordan. You know the police rushed their investigation. They took one look at a mother suffering from loss and had her deemed guilty. And that is one of the reasonable doubts they failed to properly take care of. It is a tragedy that we are here today at all. But what would be even more tragic is for you to send the mother who just lost the only family she ever had left to take a punishment for a crime she's being wrongfully accused of. All the evidence shown to you today, and you now know that when Parker Page left Jordan to go to the Lacroix Loop, Parker fell to her death over that cliff without her mother. Now, it's up to you to choose the only reasonable verdict for Jordan Ryder, a verdict of not guilty. Thank you.
Thank you, counsel. Is there anything further from the state?
Yes, the state would like to proceed with rebuttal.
Matt.
The defense has just showed us that when tough love gets too rough, there's a murder. They tried to tell us that Ryder loved her daughter, Parker Page. But in what situation does love lead to fear and ultimately murder? The defense then tried to tell us that Detective Chesney arrested Jordan Ryder without probable cause, that there were no fingerprints, that there were no footprints. But members of the jury, we have solved murder cases without forensic evidence before, especially considering that Detective Chesney had probable cause. He found the hiking stick at the tent. He found the napkin in Jordan Ryder's pocket. he found the life insurance policy, and we heard from 2 eyewitness accounts that heard Jordan and Ryder fighting moments before her death. Furthermore, nobody saw Parker Page return to the campground. Nobody could confirm with 100% certainty that she returned to safety. This defense brought up their witness, Cameron Lees, who stated that she confirmed the prosecution's theory that Parker Page never returned to the camp. She was heard yelling with her mother, and then she gave out a loud yelp at the same time that it was estimated that she died, because that yelp, ladies and gentlemen, was the last sound that Parker Page made. Thank you.
Thank you very much, counsel. Is there anything further from either of the teams before we kind of conclude today's trial?
No, Your Honor.
I'm guessing that goes for both sides. All right, then. Yeah, great job, everyone. Y'all can turn your cameras on really quickly. I've got my ballot, which I'm going to submit, and then I think that we have time for comments really quickly, so I'll run through those. How long have you all been working on this case for?
Like a week.
Okay. So, like Claudia said, I worked as an advisor for 2 years, and then I was the ed lead for a year. So I'm very familiar with kind of how we do the cases and the time frame that we give you all to be able to put these together. So it never ceases to amaze me whenever I get a trial like this that runs incredibly smoothly and has like great content, because like realistically, there's no way that you should be able to pull off this kind of trial given only 7 days to review the material. So kudos to all of y'all for having such a grasp on the information that quickly and being able to present it coherently. So I'll go through, I have kind of general comments that kind of follow the flow of the trial. And so when I give these, I'm going to focus a lot on things that moving forward, when you perfect it, are going to be really good. And I'll call out some things that y'all did, which were really good as well. For context, Claudia mentioned it. I did mock trial in high school and in college. I now coach a mock trial team in Texas, which came in 5th in state. So we're pretty stoked. All of you guys, I would kill to have on my team. So it's unfortunate that I can't get to coach you guys more, but let's jump right in. So with the pre-trial procedures went really smoothly. Loved all of that. There wasn't stepping on each other's toes. It just kind of flowed naturally, which was awesome. Very huge fan. So when I gave preferences around like do we need to ask to share screens? And I said, no, just go ahead and say that you're doing it. I think you all nailed like not asking me again, just saying like, okay, now I'm showing, exhibit so-and-so. Paying attention to a judge's preferences like that are one of the best things you can do, because it shows the judge that you actually like are listening. It's like if you ask me for preferences and I give them to you and then you don't follow them, it's just kind of a slap in the face for me. It's like, why'd you ask in the first place? So great job asking and great job following through and actually paying attention to what I said. That was fantastic. Both of the openings were awesome. I think that the pacing of them was perfect. The content as well, very, very good. And the delivery too for both of you, which we saw differing styles. We saw a standing and then a seated. I thought one was not better than the other. I thought both were done incredibly well in terms of the movement and the delivery. Content wise, I like how both sides, the state started it first. You gave these kind of monikers to all of the people. It's like, oh, the defendant's mother, like so-and-so, the defendant's mother. For someone that's never seen the case before, and as you kind of compete, adding monikers like that make it super easy for me to track what's going on in the case. If you just use names, I'm going to be so lost by the end of an opening. I'm not going to know who's who or where I'm at. When you just take an extra second to attach that, so-and-so, the defendant's mother, that makes it incredibly easy for me to get who's who in the hierarchy. And then the defense was really smart, and they picked up on that, or maybe they'd already planned for it, but they also used the same monikers, which made it easy for me to follow in their opening who they were talking about as well. Oftentimes I'll see it, a state or prosecution or plaintiff do great monikers, and then the defense turns around and they just use names. Now I'm back to being lost. You always kind of want to mirror your opponent with what they're doing in terms of how they're naming people, because it makes it easy to follow. So great job to both of my openers. With the witnesses and attorneys, so as a general rule of thumb, if you're a directing attorney, it's like you're directing someone, the best comment is no comment, because I'm sure you've been told on a direct, the witness is the star. You want them to be the center of the show. You don't want to be taking up too much space. You just kind of want to be guiding them down, the river of their narration. And I thought every single attorney did a fantastic job, not trying to steal the show from their witness and really allowing their witness to present the information. I think that there was a lot of really good rapport as well, back and forth between the attorney and the witness pairs, to where the questions and information flowed smoothly. Fantastic job, open-ended questions across the board. I didn't hear any leading questions, which usually, if it's your first time doing mock trial, or even in a trial setting, you get nervous, get flustered, it's easy to kind of fall back into those. I thought everyone did a good job of running really clear directs. I think that the objections across the board were all spot on. I saw a lot of great responses to the objections as well. There's probably areas to object more, but with 7 days of preparation, at a certain point, it just becomes more getting the one or two that you can out to show the judge you have a groundwork of knowledge, and then not objecting and kind of getting yourself in a situation where I'm wondering, do you really know what you're talking about? There was no objection that was made, no response that was given, where I was kind of like, I don't think you know what you're talking about, which is perfect. I mean, that's exactly what you want to do as an attorney as well. When it comes to the crosses, I thought all of our crosses were super well done when we had close-ended questions. There's a couple of times we had some open-ended ones, one of which was effective, but the majority of the time we had these like super succinct, quick cross questions. I'm going to point out one attorney at the very end. I love like short, rapid-fire questions, because they really drive home a point or make it, even if it's nothing being proved, seem like you are controlling the witness. So there's a quick run of like, we would agree that it's steep. We'd agree there's sudden drops. We would agree that the trail is treacherous. Like, it was just really quick, bang, bang, bang. And the witness is just like, yes, yes, yes. Like, it makes it seem like you're building up what it is you're offering. So when we do kind of these crosses, we want to try and emulate that. We want to have quick questions that seem like they're getting a point across. I thought that was really well done. I think that we also did a really good job of listening to what the witness was saying. So there was one time, and I want to offer this as a kudos to the witness as well. At one point, there was like a cross line of questioning, and the witness was like, "Oh, we're talking about so-and-so." Like, she kind of had a pause. It's like, "Hang on, we're talking about so-and-so." And the attorney was like, "Oh, well, yeah." Like, and they kind of re-asked the information they had just asked. Totally fine. Some people feel like, it makes it bad on them as a witness, or they did a bad job, we're going to lose points for it. Like, you're supposed to be a normal person. Like, if all of a sudden you realize, hang on, I want to make sure I know what I'm talking about, just offer that to the attorney. And the crossing attorney did a good job. Some people will try and, drive the knife in and be like, "Oh, you don't know what you're talking about." Like, no, she's like, "Oh yeah, no, we are," like, and re-ask the question. Like, perfect interaction, no points lost on either side. I honestly earned you both points because of how effectively you were able to reset where you were in the cross and then proceed with the cross itself. Let me see. It's really what I have in terms of general comments. For the closings as well, I thought that both of them were done really well. The biggest thing that I was a huge fan of was that our closings followed from our openings. So our openings kind of established, hey, this is what we want you to listen for. This is what we expect that you'll understand to be the case. The closings picked right up on those things and then showed how you delivered on them. Too often I see someone give an opening and say, hey, I want you to pay attention for this right here. And then all of a sudden it never comes to the forefront. And then in my closing, they try and wrap it up, but it's not there. That wasn't an issue at all. I thought that what was established as being the case in the openings on both sides was then followed through on with the closings as well. For both sides, I would say moving forward, one good thing to incorporate a little bit more on each side is the burden. You want to really hammer that burden depending on the side you're on. If you're the prosecution, I should say, you want to make the beyond a reasonable doubt seem like it's something that happens on an everyday basis, right? Like, hey, we know it's the highest burden, but to be clear, it's pretty rational if you think about it. And if we're the defense, we really want to line it up and say, hey, this is a super hard to meet burden. They're not going to be able to get there because of X, Y, and Z. And again, the birds were referenced, which is good. I'd say as a stylistic thing, you want to hammer those a little bit more when you get the chance in the closing. Witnesses across the board, great content knowledge. Like I said, kudos to you. It's hard to get those fact statements down. I thought a lot of the characters that were done were super well done as well. Our cop was a good cop. He wasn't, kind of all over the place or being too emotional. He was very factual about the way he was getting the information out. The defendant was, establishing that she was in a dark place. She was stressed, panicked, et cetera, et cetera, et cetera. When all these things were happening, like the character that we would expect to see from the witnesses was there across the board, which lent credibility to the testimony as well. So I would say, again, across the board, fantastic job for everybody. I'll hang around it if I guess people want more individual comments, but that's all I've got for y'all. I have no idea what the process is next. I'm sure our bailiff can tell us.
Yeah,